Okay, I think we've given everybody long enough to join in now. Don't want to keep you all waiting any longer. Welcome everybody to the fourth day of our virtual online housing conference. We wish it could be the attended housing day that we used to have, and hopefully we'll have again next year. We do miss meeting you all in person. But I'm sure you're going to enjoy this morning's session about housing related judicial review, even if we can't meet you all in the flesh, because we've got three excellent speakers and me for you to look forward to hearing. So we've got Ricardo Calzavara, Matthew Feldman and Andy Lane, and we will be talking to you about various aspects of judicial review. Ricardo will be giving you an overview of the kinds of challenges that we can get. I will then be looking at some of the procedural issues, including some of the recent changes that have happened. Andy will be talking about the public sector equality duty and making sure that we do that properly, not just as a tick box exercise. And then Matt's got the very interesting question of the extent to which housing associations are susceptible to judicial review. So without further ado, I will remind you that a recording of this webinar and a downloadable copy of the slides, as it says on the screen, will be available from our website once we finish. But meanwhile, at the top of your screen, you should see a chat box and a Q&A box. If you put your questions, burning issues in the Q&A box, I'll try and keep an eye on them as we go along. One of the panelists may answer them online, or we may answer them in the course of the chat that we're having. So please feel free to raise any burning issues, that then we'll try and answer all your questions as we go along. We're going to start off with Ricardo, and he's going to be talking about remedies. So over to you, Ricardo.
Good morning. It's often said that judicial review is a remedy of last resort, but what does that mean? In practice, it means that if there's a suitable alternative or adequate remedy available to the claimant, the court is very unlikely to give permission to proceed by way of judicial review. And that makes an argument about adequacy a very useful tool in the armoury when defending threatened judicial review proceedings. So what does adequacy mean? As with all simple questions, there's no simple answer, and the cases show us that it depends on the circumstances. It's helpful, though, to know what the cases are and what guidance they give us. K, the first on your slide, is the classic example of a human rights defence to a claim for possession, and it gave us the old Gateway B defence, so you'll be familiar with it. In that context, so not a judicial review claim, Lord Bingham said that it meant that if other means of redress are conveniently and effectively available to a party, they ought to be used before resort to judicial review. So far, so simple. The next case I want to look at is L. That was a JR, and it involved bribery offences perpetrated by a company. The facts in brief are that a third party sought a judicial review claim of the SFO's decision not to compel the company to disclose the outcome of an internal investigation. The relevant issue for our purposes was whether the admin court was the appropriate forum in which to determine whether it should have compelled the disclosure. The divisional court held that, and beware the long quote coming up, there is no fixed or definitive list of the alternatives that the court will consider sufficient. They may be judicial, but they need not be. The factors that the High Court will take into consideration include the nature of the alternative remedy, and in particular, whether it's statutory and whether it was the intention of Parliament that it amounts to the mechanism or forum in which disputes were to be resolved, the utility and ease with which the alternative remedy can be invoked, cost and expense, the need for fact-finding, utility and finality, the desirability of an authoritative ruling on the point of law arising, and the strength of the issues. There's a lot to be unpacked there. So the bullet points: there's no fixed list of factors. It's not necessary that the alternative be judicial. The nature of the alternative remedy is the primary consideration. If there is an indication that Parliament intended to oust judicial review, that will be determinative. How easy is it to invoke the alternative? How much does it cost? Will it give rise to a determinative ruling? And even if all those things tell against giving permission for a judicial review claim, is there a wider point of principle that means the admin court should consider it anyway? Another thing to look out for is interim remedies. Imagine there's an alternative remedy, but it isn't possible to obtain any interim relief, such as an interim injunction. In such a case, the alternative may not be adequate, even if every other feature of it makes it so. And the case on that is Thames Wines. Thames Wines was a judicial review claim brought against HMRC after it had deregistered a company for VAT because of alleged VAT fraud. The company brought a judicial review claim against that decision and sought interim relief to suspend its deregistration pending the hearing of the claim if permission was granted. And that's a classic interim relief remedy. The deputy judge decided the claim wasn't arguable, so it wasn't necessary to consider the question whether an alternative remedy without power to grant an interim injunction was still adequate. But you get the discussion of principle there. There's a good case on that. And then there's the distinction between questions of fact and law. So could I have my next slide? Thank you. Sure was an application for permission to JR the defendant police force's decision to arrest and detain the claimants on suspicion of terrorism offences. The claimant's argument was that these were claims relating to public bodies, so that it was necessary to bring them by judicial review, which sounds like an ambitious argument. The divisional court made it clear that where there are disputed issues of fact, the fact that an alternative process is capable of resolving those disputed facts is likely to make it adequate and possibly more suitable in any event than judicial review. It then refused permission to bring the claim because there was a private law remedy in the tort of false imprisonment, which made it much more adept at resolving disputes of fact. On the other hand, in Baker, Lord Justice Simon Brown remarked that judicial review is more likely to be appropriate when resolving questions of law, particularly in a developing field, which echoes what had been said in L that we looked at a moment ago. That might now seem obvious. He also held that which of the two routes is to be preferred depends on which is the more convenient, expeditious, and effective. That was a case about the closure by a local authority of a care home without first having properly consulted its residents. In Calvley, which is the last case on that slide, Lord Justice May warned against applying that which is more appropriate test if the alternative remedy is a statutory appeal. It was a case about the dismissal of 5 police officers. They had a statutory right to appeal against their dismissal, but instead brought a JR claim. The divisional court refused the claim because there had been an alternative remedy, the statutory right of appeal. And on appeal, the Court of Appeal allowed their appeal against the refusal by the divisional court, saying that this was an exceptional case because there'd been unconscionable delay in the appeal process, and the officers should therefore have had a speedier determination of their grievance. My next slide, please. In South West Water, Lord Justice Simon Brown held that the existence of a statutory appeal mechanism is almost certain to exclude judicial review. The facts are complicated, but In brief, the claimant brought a judicial review claim against an abatement notice issued in respect of nuisance arising from sewage works. The claimant also brought an appeal against that notice to the Magistrates' Court through the statutory route. The reason for seeking remedies through both routes was that the magistrates couldn't hear the appeal quickly enough. The admin court granted permission, quashed the notice, and then the local authority brought an appeal to the Court of Appeal, which in turn held that although a statutory appeal mechanism was almost certain to exclude judicial review, this was a case on the facts in which it had been appropriate to seek judicial review. And then in Oxfam, Mr. Justice Sales held that the general statement of principle that an alternative statutory remedy will be adequate and judicial review will therefore not follow, possibly did not apply where that alternative route limited the scope of the argument that might be run. So, for example, if arguing bias or procedural fairness to classic judicial review grounds was prohibited, that might make the alternative inadequate. Finally, on this point, a non-statutory appeal mechanism such as a complaint to the Ombudsman is unlikely to be an adequate alternative remedy, but obviously, as ever, it depends on the facts. The most famous example is Leach, which you have at the bottom of that slide. Lord Bridge held that a prisoner's right to petition the Secretary of State was not an adequate alternative remedy because the Secretary of State didn't have the power to quash an underlying finding in a case where the prison governor had decided to deduct 28 days remission. So all that to say, it's not always right that because there's an alternative appeal mechanism, that's the end of the road for judicial review. And then the next slide, please. We have the lead case in the homelessness context, Adesotu. This was a homelessness appeal to the County Court by Section 204 of the 96 Act. Two of the grounds included allegations of disability and discrimination arising from disability. The circuit judge struck them out, holding there was no jurisdiction to consider them because the County Court didn't have jurisdiction to make findings of fact. That's a case called Bub, and more importantly for our purposes, because the Equality Act didn't permit assertions of discrimination to be decided by way of homelessness appeal. You have the references to the statute in the slides. The Court of Appeal upheld the judge's striking out of those grounds. Lord Justice Bean, who gave the only substantive judgment, held that a homelessness appeal wasn't a judicial review claim, which meant that allegations of discrimination couldn't be raised. That helps local authorities in the sense that a homelessness appeal can't include grounds alleging disability discrimination, but those grounds can be brought by judicial review. So this is the sort of case in which it's not possible to defend by asserting that there's an alternative statutory remedy. And as many of you will have heard, the Supreme Court refused further leave to appeal earlier this year. So that is the authoritative determination on that point. And that concludes my slides.
Thank you very much, Ricardo. I'm going to talk about procedure to a certain extent because judicial review is a very procedural driven remedy, but it is one where the procedure is given to you very clearly, partly by the court making very clear directions, and partly, of course, by the rules and regulations. Also, of course, the administrative court guidance updated every year. So look at the administrative court guidance. It's a how-to manual that really is extremely helpful, and every practitioner should have that bookmarked on their web pages. Timing in judicial review cases is everything. When I was a little girl, Friday 5 to 5 was crackerjack. Remember that? Just me then. Okay. These days, Friday 5 to 5 is when the judicial review claim lands on your desk. Because to a great extent, claimants are in charge of the procedural timetable. And so it's an old trick, but it sometimes works. Leave issuing until last thing on a Friday evening when everybody's gone home or they've gone out for a drink. And so things get slipped by, and so they can get the out of hours judge to make an order. Now, the trouble with judicial review, although it's procedurally very clear, it's not very clear which judge you're going to get and how that judge is going to respond. It's pretty much a lottery as to how judges are going to respond to applications. Some judges are very keen to ensure that claimants seen as vulnerable are protected. Some are more keen to ensure that local authority resources are preserved and that the right of the local authority to be the primary decision maker is respected as well. So on that Friday, 5 to 5, an out of hours judge may be hearing an application and can either decide perhaps to give the local authority a chance to respond to the application, or can give it and make sure that the local authority has the opportunity then to apply to set it aside. Meanwhile, over the weekend, the applicant gets the accommodation or whatever the remedy may be. Usually is accommodation that we're talking about on these Friday hearings. It's not just in the course of applications that timing is so essential. Later down the line, there are other timetables to meet, and that timetable may be an expedited timetable. Expedition is something that the court has the power to grant, and it is sometimes overlooked that Practice Direction 54B says that the claimant must ascertain the position of the defendant in relation to expedition before seeking an order that the claim be expedited, and see what the defendant says about it. It is also set out in Practice Direction 54B that there is a duty on a person seeking interim relief, not just to say why interim relief should be granted, but to give all the arguments on the other side. And that, in my view, is a duty that is very often breached. The point at this stage is that you should be having pre-action correspondence. You should have a pre-action protocol letter. This should warn you what is coming, and it's your chance to front load your response to judicial review. And this is something that is so important and that perhaps our clients are not quite as understanding about. A pre-action protocol letter is the first shot across the bows, and it's also responding to that is your first chance to blow them out of the water. So it is a moment where you can start either reviewing your decision, getting your evidence in place as to why this is the right decision, and writing a letter that should then be put before the court. It's always a good idea in response to a pre-action protocol letter to say, we don't agree that this is urgent. If that's the case, we don't agree that your arguments are right, and please ensure that this is put before the judge if you make an application. There is perhaps a little bit of a tendency in some of our regular opponents to scamp that aspect of it, making sure that they're giving full disclosure. There are certain solicitors firms who've been criticised for that recently. They have got a duty to make full disclosure and explain, as I say, not just why interim relief should be granted, but why it should not be. The best way of complying with that duty is to put your arguments in a response to a pre-action protocol letter before the judge. And so this is your chance to get your defence in first. One of the questions that came in on email before we started was whether you've got an obligation to respond to a pre-action protocol letter, which isn't in the format that's laid out in the rules. And I would say, yes, I'm afraid there is, just because it's not compliant with the template that's given. It doesn't mean to say it's not notification of the arguments and the matters that you are going to have to respond to. And whilst there may be an argument on costs at the end of the day, you should still treat that as your opportunity to respond to what is being said against you, to get your defence ready, to put people on notice, for example, that there could be an application for accommodation. So somebody should be ready to arrange accommodation if it is ordered. do not think that an application for interim relief, an application for expedition will just roll away if you ignore it. It will not go away, it will get bigger. People who are legally aided need to get interim relief in order to get legal aid funding at the higher rate, really. So they've got a huge incentive to follow up a letter before action by issuing a claim. This is an important stage of the proceedings, and it's important that you take the opportunity to respond fully as possible. The claim then arrives. The forms have recently changed. It's to make them more suitable for online filing, and so they look very different from the ones that we used to type in on Adobe or fill in by hand. The government's new judicial review bill that's now going through Parliament concentrates a lot on online procedures. There's going to be a whole new online procedure committee. But it seems to me that the admin court is leading the way on online filing and online hearings as well. During the pandemic, I've had a lot of online hearings, and it's been really effective to have Zoom calls with your judge, and you can read the judge's face. It's the absolutely paradigm example of something that can really be done well by remote hearings, but it is now the case that we're going back to face-to-face hearings, back into the Royal Courts of Justice and wearing wigs and gowns. My recommendation is always to put in an N462, which is the form of acknowledgement of service. So this isn't necessarily completed with all the grounds for contesting. Fill in the fact that you've got, your name, your address. We're here, we're thinking about it, we're not just ignoring it. Please contact us before you make any orders. This is how you contact us. So it just puts you in the ring in order to ease the way in future. And you can then submit grounds for contesting afterwards. And another tip that judges are being quite hot on recently is for you to ask for your costs in either your acknowledgement of service or your grounds for contesting. Give a figure for that, so the judges know how much you're asking for. Also, so any claimants who might not be legally aided know what's at stake, what they are gambling on, and just so that they are aware that there is going to be a claim for costs, there is going to be consequences to bringing this kind of claim. So put this in as quickly as possible, come back later and do full grounds for contesting. This is what the new N462 looks like. As you can see, it's a little bit more like filling in your online application for benefits or something. It's a lot more online friendly. So you've got your claim for interim relief, whether that be an order to accommodate somebody or similar applications. The first thing you have to do is look at where you are. Has an order already been made that you're going to have to set aside, in which case you're on the back foot already? Or is this something where you've got a chance to defend the application? Is it worth the candle? You've got the costs of instructing counsel, you've got the costs of attending court, putting in application. And is this something where you're really so sure that interim relief should not be granted? It's not too late to take a decision if you haven't done it properly. You can do your Mohammed letter even at this stage. Very often, of course, you get your applicants asking for an order for accommodation before you've actually taken that decision. That's bad judicial review practice, but the courts are quite flexible about treating that as a rolling application for judicial review. If it's a challenge to the fact that you haven't taken a decision, the court can quickly shift gear and say, okay, it's now a challenge to the decision you've taken. And so, you can shuffle along on a rolling basis. And it is never too late to deal with issues that an applicant or a claimant has raised in their claim for judicial review. And of course, if you think, oh, yeah, I did miss that, put your hands up at this stage. Better to do that sooner rather than later. When it comes to interim relief, I have spent the last couple of years arguing what the test for interim relief is. The test should be whether the applicant has shown a strong prima facie case that they're going to win at the end of the day. And this is a judgment of Lord Denning back in Defalco and Crawley. It was recently confirmed in a case against Belfour and Borough Council, that was at the end of last year, that when you're considering application for interim accommodation, that is to test a strong prima facie case. The point is, what the court is doing at this stage is balancing, on the one hand, the chance that the applicant had been done out of something that they were entitled to by a bad decision of a local authority, and on the other hand, that it's an applicant is asking for something that they're not entitled to because you got a good decision of the local authority. And so balancing things up, the stronger the case that you've got a bad decision, the more likely the balance is to tilt in that favour. You're also going to consider things like the impact on the person of not getting interim relief. And so when you're talking about accommodation, of course, the fact that they'll be street homeless, how will they be able to bring their appeal, bring their review, things like that, where will they go? And the question for the court is how that balance should be struck, given that the local authority is the primary decision maker. They are the ones who know the strains on their own stock and things like that, how the case should unravel in future. And the question should be, have they shown a strong enough case, along with all the other elements, to tip in favour of granting interim relief? And so when you're thinking about your response to that, so you need to think about the kind of thing, and that's what Mohammed was all about, Camden and Mohammed in the context of interim relief in terms of accommodation pending review or pending appeal. All those factors that are set out in the Camden letter are really relevant to all the other applications for interim relief. Is it a good case? What's going to happen if you don't get it? Who's going to be worse off at the end of the day? I've already mentioned the question of costs, put that in your acknowledgement of service. The general rule is that a defendant doesn't get the cost of attending an oral permission hearing. That is not an inflexible and unbreakable rule. In a recent case, well, recent-ish case, Al-Ali and Brent, 2018, costs were awarded at that stage because the claimant had misled the court. Mr. Al-Ali had actually gone so far as to forge medical evidence, and Brent had to go through a considerable degree of fuss and bother to show that he had been so fraudulent. Absolutely astounding that he thought that he would get away with that, but he was ordered to pay Brent's costs, rightly so. Another reason for awarding the cost of attending an oral permission hearing might be that the local authority or the defendant to the claim needs to attend the oral permission hearing to defend a claim for interim relief. I can't find a case that actually says that, to be honest, but that is my experience. Judges will say, yes, you had to turn up, you had to defend the claim for interim relief, so we will give you the costs of attending. Of course, in many cases, it's going to be no more than a nominal award of costs because you've got somebody who's legally aided, so it's costs not to be enforced without permission of the court. Mount Cook is the authority for saying that other exceptional circumstances, which are not limited, may be a reason for awarding costs. Hopefully at the oral permission hearing, you can get the claim ended at that stage. However, after that, if it goes on, there may be other stages at which you need to remember my first slide, tick-tock, tick-tock. Always do ensure that you abide by court's directions, because all you're going to do if you miss that is to really hack the judge off. Think about how you're going to present your case in the more favourable light at the end of the day, and that includes things like evidence from decision makers in the appropriate case. And so once permission is granted, if it is so granted, that's your signal. The gun goes off to get your act sorted out. So you're thinking about all the things that Ricardo just mentioned about alternative remedies, and you're also thinking about things that Andy's going to come along to talk about, the PSED, and also things like, are you a justiciable authority? So that is what Matthew is going to be talking about now, and I shall hand over to him.
Okay, thank you very much. Well, as Kate's indicated, I'm going to be talking about the circumstances in which housing associations are susceptible to judicial review. And in the 10 minutes or so available, I'm going to be referring to three very interesting cases, or I hope they're going to be interesting. The first one is Weaver and London and Quadrant. Secondly, MacLeod and Peabody Trust Governors. And finally, Zed and Hackney, London Borough Council, and Agudas Israel Housing Association. I'm very pleased to report that Andy, in fact, was involved in Zed and Hackney, along with Matt Hutchings, QC. So very familiar with that case and acted for the successful local authority. One of the key points I should probably emphasize at the outset is that whether a housing association is susceptible to judicial review is fact sensitive, as hopefully the outcomes of the three cases that I'm going to be looking at will demonstrate. So Kate, if we could just move on to the next slide, that would be great. So the first case is Weaver and London and Quadrant Housing Trust, which eventually went up to the Court of Appeal. Briefly, the facts are that London Quadrant served on its assured tenant, the claimant that is, a notice of seeking possession for rent arrears under Ground 8 of Schedule 2 to the Housing Act. The tenant judicially reviewed that decision to evict her, asserting that was in breach of a legitimate expectation generated by guidance issued by the Housing Corporation that Ground 8 would not be relied upon in such circumstances, and arguing that her Article 8 rights were infringed. What the claimant needed to demonstrate was that in the exercise of those eviction powers, London and Quadrant was a public authority within the meaning of Section 6(3)(b) of the Human Rights Act and susceptible to judicial review, and that the act of terminating the tenancy by service of the NSP was not a private act within the meaning of Section 6(5) of the 1998 Act. Kate, if we could just move on to the next slide, that'd be great. Significantly, for the purpose of this case, London Quadrant received a substantial public subsidy, and its allocation and management of housing stock was subject to statutory regulation, which is an issue that arises both in the divisional court and is commented upon in the Court of Appeal. Kate, next slide, please. So in the divisional court, the claim based on legitimate expectation was dismissed, but the divisional court did make a declaration that the management allocation of housing stock by London Quadrant, which included the decision to terminate the tenancy by service of the NSP, was a function of a public nature. And in these circumstances, it was to be regarded as a public authority in that respect for the purposes of Section 6(3)(b), the Human Rights Act, and London Quadrant was amenable to judicial review on conventional public law grounds in the performance of that function. London Quadrant appealed to the Court of Appeal, and it was a relatively close decision, 2-1, with Lord Justice Ricks dissenting. But ultimately, the majority held that there were a number of factors that established sufficient public flavour to make provision of social housing by a landlord a public function, and again reiterated three main points. Firstly, that L&Q received significant capital payments from public funds to provide subsidised social housing. It worked in close connection with local government and helped to fulfil local government's statutory obligations. And equally as importantly, it was itself subject to regulations designed to further the objectives of government policy. And ultimately, the Court of Appeal held that the act of terminating the tenancy in these circumstances was necessarily involved in the regulation of the landlord's public function and was itself a public act subject to convention rights considerations. Now, as I understand it, there were some rumblings about a further appeal to the House of Lords, but that did not eventuate in the end. So the Court of Appeal decision is the one that we have, and in some respects, I think it could be described as a trailblazer in this area of the law. That takes us to the case of MacLeod and Peabody Trust Governors, in which significant reference was made to the Weaver case. The brief facts are that in June 2009, the Crown Estate Commissioners granted the claimant an assured tenancy of a flat. Under the tenancy, assignment was prohibited, and it was also specified that the rent could not exceed 60% of the market rent for the flat. Just under a couple of years later, Peabody bought about 1,200 properties, including the flat, from the commissioners. And Peabody, again, this is quite an important feature, but Peabody it issued bonds to finance the purchase, and the transfer of the properties was subject to a nominations agreement, which provided that Peabody could only let the transferred properties to key workers. Now, Peabody had a policy by which tenants were allowed to exchange their tenancies with other tenants of social landlords. In May 2014, the claimant requested by telephone whether he could register his details on a website facilitating mutual exchanges between tenants of social housing, was told on the telephone that he could do so. A year or so later, he completed Peabody's application form for a mutual exchange, adding a handwritten note that he was disabled. And fairly shortly thereafter, in fact, only a few days later, Peabody replied that it had made a mistake by telling him that he could register with the website, and that he was only allowed to exchange his tenancy with another key worker in one of the transferred properties. The claimant, unhappy with this state of affairs, sought judicial review of the decision to refuse his application for a mutual exchange. He contended that Peabody had failed to follow its own policy, and that the decision was irrational. He also asserted that Peabody had failed to discharge its public sector equality duty towards him as a disabled person. The main thrust of Peabody's case was that it had not been acting as a public body. If we could just turn to the next slide, thank you. So the claim was dismissed, Mr. Justice Davis holding that Peabody had purchased the claimant's flat from the commissioners using funds raised on the open market, and the rent levels were above those for most social housing properties. It was held that the transfer of properties were not social housing for the purposes of Section 69 of the Housing Regeneration Act 2008. And importantly here, the Divisional Court held that the decision not to allow the claimant to assign his tenancy was not a decision in the exercise of a public function by Peabody. And so the decision was not susceptible to judicial review. It was also held that Peabody were entitled to depart from the policy, assuming that that it applied to the claimant. The decision could not be said to be irrational, and finally, the medical evidence simply did not support the claimant's contentions, and so that ground was also refused. Finally, the case of Z and another against Hackney, London Borough Council, and Agudas Israel Housing Association. This case eventually went up to the Supreme Court for determination. But just dealing with the brief facts again in relation to this case, Hackney had entered into a nominations agreement with a charitable housing association, Agudas Israel Housing Association. They provided social housing primarily to members of the Orthodox Jewish community, under which applicants for social housing who had been assessed as having priority needs could be nominated by the authority to properties owned by the association. The claimants comprised a mother and her 3-year-old son, who had the highest priority rating for rehousing. They sought judicial review, challenging the lawfulness of the association's arrangements for the allocation of its social housing properties, on the basis that they effectively precluded anyone who was not a member of the Orthodox Jewish community from becoming tenants of such properties, and challenged the nomination arrangements on the basis that they unlawfully discriminated against the claimants as non-members of the Orthodox Jewish community, which was in breach of Section 13(1) of the Equality Act. Now, in dismissing the claim in the Divisional Court, Lord Justice Limblom, Sir Kenneth Parker, held that positive action could be taken under Section 1581A of the 2010 Act in relation to those with a protected characteristic who suffered a disadvantage which was said to be connected to that characteristic. And under Section 1581B, positive action could also be taken where those with a protected characteristic had needs which differed from those without such a characteristic. And it was held that while positive action in favour of a preferred group might cause disadvantage to other groups, it could also be proportionate if the advantages to the preferred group outweighed the disadvantages. So again, a question of proportionality was central to the Divisional Court's decision here. But in circumstances in which it had been determined that the association were legally entitled under Section 158 and Section 193 of the 2010 Act, Section 193 being the provision relating to charities, to discriminate in the allocation of its available properties in favour of members of the Orthodox Jewish community. The authority, Hackney, had no legal right or power to insist that the association jettison its lawful arrangements and make allocation decisions without regard to those arrangements. Essentially, it was held that the authority had not engaged in direct discrimination, contrary to Section 31 of the 2010 Act, and the claim against it was dismissed. The Court of Appeal dismissed the claimant's appeal, and a further appeal to the Supreme Court was also dismissed on the basis that the conventional approach to proportionality was applicable, that the range of permissible legitimate aims within the meaning of sections 158 and section 1932 of the Equality Act included enabling persons who shared a protected characteristic or to meet needs particular to persons with the protected characteristic. Ultimately, the Supreme Court held that it was proportionate for the association to operate a blanket policy to allocate its properties to members of the Orthodox Jewish community in order to promote that legitimate aim. It was held that it was a proportionate measure. Finally, the Supreme Court considered that the Divisional Court had correctly directed itself in respect of the test of proportionality, and that the Divisional Court had made appropriate and the correct findings of fact. So, Kate, back to you.
Go straight to Andrew.
Thank you very much, Kate. Thank you very much, Matt. I think there's a question, Matt, for you in the Q&A, so we've left it for you. On to the public sector equality duty, which obviously is a public law duty and therefore, unsurprisingly, when it comes to judicial review, plays a heavy part in many claims. Firstly, apologies if I'm not seeming to be looking at you, but my camera's somewhere at the top of the machine, and if I stare at that, I can't see the screen. And also apologies for the headset. I was going to say it makes me look like a DJ, but given my generation when DJs were around, I think I'll say it makes me look like a pilot. I think that's probably safer. But anyway, the public sector equality duty, which the next slide will actually set out, but I just wanted to make some preliminary points as to its purpose. It is, and it's always worth saying, an incredibly important duty, whatever one argues in terms of its relevance to a particular case. There was a recent webinar that Cornerstone Barristers did, and I did it with Ruchi and Ryan, which you'll see on our channel on YouTube, which will give you more details. But it is a duty to have regard. And as you can see from this first reference there, it's to inform the decision-making process. It applies to both policies and individual decisions. And if you look at one case in a housing context, I always say Mr. Justice Turner's paragraph 42 in London and Quadrant Housing Trust and Patrick is worth the read. It's often difficult to say when people say, yes, but how do I apply it and how do I comply with it? Indeed, one of the questions we had in advance was, how do I avoid simply having a tick box exercise? And it's a very valid question. And of course, there's often a concern, for example, in housing homelessness review decisions as to whether there's just a cut and paste job when there's the various references to cases such as HOTAC and so on set out. I think what I would say is that what one must do is obviously appreciate the reality of the situation. So in an individual case, if one, for example, has somebody who has a disability, one is clearly having regard to that, both in terms of how that impacts upon, for example, their ability to maintain the tenancy and their behaviour, as well as how that impacts upon their ability to deal with matters should, for example, an injunction or a possession order take place. And of course, evidence of that may be very structured. So if you're reviewing a policy, for example, an antisocial behaviour policy, you would expect perhaps to see an equality impact analysis. Whereas if you're looking at a decision to issue possession proceedings, or indeed an issue, a warrant for possession, one may not have that formal document, but one may have a paper trail clearly demonstrating that efforts were made by the public body, local authority housing association, to consider the person's protected characteristic such as it is. But as you can see from the last bullet point here, it doesn't amend the statutory powers and functions of a public authority. It's there to have regard. It's not there to have a result. And that's the key issue. If we can have a look at the next slide, Kate, because we can actually see what the legislation actually says. Apologies for the small type. It's really subparagraph 1, which sets out the duty itself. It's always interesting when I see these matters pleaded in defences, for example. People very rarely indicate whether it's A, B, and C, or whether it's a combination of all three. And similarly, in judicial review claims, it's very rare to see it as a individual claim of judicial review, as opposed to an add-on at the end of a wider complaint, which would include matters such as discrimination. But it is an important duty. In particular, B is a common one, the advancement of the equality of opportunity between persons who share a relevant protected characteristic and persons who don't. And all I would say on this page, finally, is you'll see from subparagraph 6 that compliance with the duties in this section may involve some persons being, to my words, being treated more favourably than those without that protected characteristic. And it's worthwhile considering that matter when one's looking at an individual case or indeed a policy. So when one, as I say, looks at cases such as the London and Quadrant case previously referred to, this is another example in Fisher and Durham. Fisher, incidentally, was a case about a noise abatement notice, an unsuccessful claim against the local authorities issuing of a noise abatement notice. And it included, as I indicated previously, grounds other than the PSED. It included, I think it was section 15, disability discrimination complaint. But it did include the PSED as well, and an alleged breach. And you can see there what Mr. Justice Julian Knowles says. Council officers also had due regard to the protected characteristic of others and their needs in relation to the PSED, gave close considered involvement to the issues arising in this case. It had in mind the suffering that had been and was being endured by the claimant's neighbours. And I just pause there to say that, of course, you're not just looking at the claimant's position, you're looking at the position in many instances of other people as well. So in allocation schemes for those other people who require housing as well as the claimant. They were in an intolerable situation, pointed out that the PSE does not amend the statutory powers and functions of a public authority, and therefore doesn't limit the powers to issue an abatement notice, provided it took into account. I've said at the bottom there, I've referred to the case of McDonough and Newport, which will come up later as well. That was a challenge to a local authority's gypsies and traveller site allocation policy, which only applied to those with a demonstrable aversion to bricks and mortar. And that wasn't a successful challenge by the claimant, but indicates it's not just about individual decision making, but it is about policies as well. Looking at the issues on the next slide, as I've indicated already, rarely a ground on its own. Ibrahim and Westminster I've cited for that proposition, A, because it's a very recent decision, B, because it's another one of those decisions which I would always recommend people have a look at, because it's a very well set out judgment of Mr. Justice Sewell, and also it obviously in a housing context, it was talking about the ability and the practicality of an individual making a fresh application for homelessness and the local authority rejecting that as a fresh application. There was issues as to irrationality, issues as to the unreasonable exercise of discretion. And Mr. Justice Sewell, what I would direct you to is paragraphs 125 to 127 of his judgment. So as you can see, he went on a bit, but it's a long judgment. He says that the PSED did as a matter of substance require each of the relevant decision makers to maintain a sharp focus on the claimant's mental health and consequent protected characteristics of disability, as it affected the question of whether it would have been reasonable for her to remain at the accommodation, and particular on the sub-issue of subjective reasonableness. For essentially the same reasons as have led to my conclusion this was an obvious matter to consider at each stage, I conclude that there was a breach of PSED in this respect, and notwithstanding that the point was not expressly raised in submissions by or on behalf of the claimant. And of course, one knows through cases such as Pieretti that in a homelessness context, which of course in the county court is effectively JR in the county court, one doesn't have to raise the question of the public sector equality duty if one is an applicant or one is a claimant. It is there to be considered by the decision maker, and it's the same in the divisional court and in the administrative court. So he found that there was a breach of the public sector equality duty in that case. Although what is interesting, what he also says is that, in my judgment, this takes the claim no further, because he held in any event it was an unlawful exercise of discretion and an irrationality, and effectively said the PSED didn't add very much. I would just add, away from what you see in front of you, Kelvin and I did a case of Hillingdon and Gulu a couple of years ago, where there was a complaint as to an allocation scheme. And of course, allocation schemes are common fare for judicial reviews, and in particular challenges to questions of qualifications, in this case the residence requirement, which was 10 years, and it was alleged that that was discriminatory. And in a sense, the main issue was discrimination, not even Article 814, but under the Equality Act, in particular Section 19 and Section 29. And it was held that it was discriminatory towards refugees and Irish travellers. It was also, incidentally, a breach of the public sector equality duty, but in many instances it may be said it didn't add a great deal to the claim, because, as I say, it was already a determination that it was discriminatory. However, it is important to note that just because something isn't discriminatory doesn't mean that there has been compliance with the PSED. And therefore, if one has both matters pleaded in a judicial review claim, one has to address them both seriously. And so even if you succeeded on the discrimination claim and the reaction of the local authority or the housing association was proportionate, it doesn't mean that they haven't breached the public sector equality duty, because it may be they didn't have sufficient regard to the protected characteristic at issue. Just very quickly on this screen, sorry, if you can just go back, Kate. The discharge of the Section 1932 duty is a common issue, as is Section 188(3) accommodation for temporary accommodation pending the outcome of review. It's very common, and also it probably doesn't apply to many housing cases, but just to note that there is a territorial limit. In other words, in the Turani case, which was about the exclusion of Palestinian refugees from the vulnerable persons resettlement scheme, which was mainly put in place to deal with people coming from Syria, that didn't apply in respect to the PSED because they were actually outside the UK. But as I've already indicated, impact is not always conclusive. And you can see that reference that I quoted earlier from Mr. Justice Sewell. The final slide is having talked about the fact that, of course, one can challenge individual decisions of a public authority or of a housing association exercising a public function. But of course, one can deal with what we know as the macro decisions. And so we have the Encube and Brighton and Hove City Council case, which you see reported there, which didn't have to and didn't need to have any reference to the PSED, because it was, although it could have done, because of course it was a simple case as to saying there ought to be assistance for those who are street homeless. And it was obviously felt by those bringing the claim that it wasn't necessary to invoke the PSED, albeit they were ultimately unsuccessful. The DMA and Secretary of State for the Home Department was a case in which, as you can see, the Secretary of State's approach to a duty to provide or arrange for the provision of accommodation for destitute failed asylum seekers did constitute a breach of the PSED. And in respect of that, it's interesting to note that there was a fairly damning indictment of that. And if one looks at the judgment at paragraph, I think it's, let's have a look, 311, one can see that is set out in a very clear way. But again, that's something where, particularly with policies, the PSED becomes a much more important issue. And going back to the McDonough case, as I say, it's an allocation policy. And although they failed in their claim, it demonstrates that, in fact, the challenge was to a policy. I think where one ends up with this discussion of the PSED in this very whistle-stop tour is really this. As Matt has said, anyone who's a public authority or exercising a public function is susceptible to judicial review. One of those grounds is obviously going to be the public sector equality duty in those circumstances, particularly if a protected characteristic becomes particularly into play. Often in housing, that's seen as being the disability, but of course it could be any of the other protected characteristics which one sees in Section 4 of the Act. And in relation to the difference between individual decisions and policies, clearly with individual decisions, greater tolerance is given by the courts. You have a look at cases such as Powell and Decorum to see that Lord Justice McComb in that case, for example, made it quite clear context is crucial. If you're doing a policy, you really have difficulty explaining why you haven't properly considered the public sector equality duty. If, however, you're doing an individual decision, the sharp focus that we looked at earlier is less of an issue, because of course one's dealing with a very quick management decisions. And my final comment is simply that even if one's breached the decision, of course, if the court determines, and this is under Section 31, subparagraph 2A of the Senior Courts Act 1981, that it's highly likely it would have been the same decision, it won't get you home. And again, if you look at the housing context, not in judicial review, but of cases like Dodana and Ford and Aldwick, one would have seen those kind of determinations, although the Supreme Court have been asked to look at Dodana again, and we'll see whether permission is granted in that case. So sorry for overrunning, Kate, but I hope that is a good whistle-stop tour of the PSED.
Thank you, Andrew. I don't think you did overrun at all, given that we started a bit late. And we have now got a moment or two to talk about question and answer session. We've only got one question in there so far, which is about the question of whether an ALMO, an arm's length management organisation, is amenable to JR. Do the test in Weaver apply to that? So Matthew, can you give your answer to that one? And well, meanwhile, anyone else who's got questions, get typing.
Well, I think the context of the relationship between the ALMO and the authority would be important to establish, as would the contractual relationship between the two. I think much would depend on whether, as is often the case, I think that that if the local authority retained strategic decision making, then I think it's probably doubtful, but context is king here. It would really depend on the relationship.
And the other thing to add to that is that there are certain decisions that people take, or rather that organisations take, that are just like private decisions, going down to Sainsbury's, buying a sandwich, as opposed to buying a house. If you're an individual, translate that up to the judicial review arena, and if the ALMO is, making a decision as to whether to buy a packet of pencils, that's going to be something that's not amenable to judicial review, whereas more broad-ranging decisions might be a more public kind of decision, and we will possibly see those in the judicial review arena. If I was being instructed by an ALMO, I'd say I'm not amenable to judicial review. prove that you are. So
but it is fair to say, Kate, isn't it, that there's nothing per se that says now Mo it isn't susceptible to judicial review, just like anybody could potentially be if they're exercising a public function. And I think, you know, we had for a while, didn't we, with housing associations, they were seen as being a private body for other purposes and for certain funding purposes. But of course, you know, if you take the example of a housing association which has taken over a local authority stock, it's difficult to perceive as a more obvious exercising of a public function if they're dealing, for example, with possession claims and you know, injunctions and such like. Whereas perhaps with a shared ownership, one may take a different view, or intermediate rent properties, one may take a different view. I say may. The only other thing I would say is that Weaver, of course, although we all cite it and we all, well, those of us old enough to remember it, at the time, of course, it did rely in part on admissions. And I know there are certain people who have been dying to get a decent case back to court. But what we normally say in our pleadings is that we don't dispute at first instance that, you know, the association, you know, is susceptible to, you know, Article 8 or whatever it is, you know, the Equality Act, but reserve the position in respect of any appeal.
So that was the only question we've had in. Unless anybody else puts their hand up quickly, types a question quickly, I'm going to say thank you all very much for attending. We hope you've enjoyed that, despite Andrew's background, which has been really offensive to some people, I'm sorry to say. Tomorrow's session, sorry, this session is now going to be the recording, and the slides will be on our website for you to download and watch again at your leisure. So thank you all for attending. Hopefully see you tomorrow. Bye-bye.